Good afternoon, members of the Assembly. My name is Jeffrey Deskovic, and I served 16 years in prison, wrongfully convicted at the age of 17. I spent the 16 years in prison prior to being exonerated by DNA evidence, which not only established my innocence, but it also identified the actual perpetrator. In the 7 years since I was proven innocent, I have given many presentations across the country. I've authored more than 200 articles for a weekly column where I was a columnist called the Westchester Guardian. I've lobbied elected officials here in Albany and in Connecticut, as well as testified at several legislative hearings. I've traded personal privacy in exchange for greater awareness of issues, and therefore I have given many television, radio, and print media interviews. I recently graduated from the John Jay College of Criminal Justice with a master's degree in criminal justice. About a year and a half ago, 2 years rather, I was finally able to receive some financial compensation, and I decided to commit $1.5 million of personal money I received in order to launch the Jeffrey Deskovic Foundation for Justice. My principal concern in general is, of course, wrongful convictions. I do, however, have an interest in other criminal justice issues, and by making strategic use of my time, I'm able to lend my voice, my time, and my input. Because of my unique life circumstances, I bring to the table the combination of formal education, personal experience, as well as a lot of informal learning that I've done. I ask you to take that into consideration in assessing whatever value you will to my suggestions. I've provided written testimony. I will take Assemblyman O'Donnell up on his offer of submitting to him personally the policy issues as well as solutions. My testimony today in this parole hearing will focus on the following issues, all of which were based upon my personal experience while I was wrongfully imprisoned, things that I learned as a result of being proactive in trying to better my situation, as well as experiences of other people that I witnessed firsthand. The issues that I'm going to address this afternoon are the innocent prisoner's dilemma, the parole board's repeated reliance upon the phrase to release you at this time will deprecate the seriousness of the offense, the issue of closed-circuit parole hearings, two deficiencies in the appeals process regarding parole, specifically courts dismissing Article 78 petitions as moot, as well as raising the issue of whether courts should have the ability to grant relief in the form of ordering release. And lastly, but perhaps most importantly, the issue of elderly people in prison being repeatedly denied parole. In terms of the innocent prisoner's dilemma, it's important to understand the following context. There have been 311 DNA-proven wrongful convictions across the country, and approximately 1,700 when you combine non-DNA as well as DNA, according to the National Registry of Exonerations. Further study is ongoing, so those figures are only true as of this moment. The innocent prisoner's dilemma is the catch-22 position that I personally experienced. I finished my 15-year minimum and appeared in front of the parole board. The dilemma I faced was whether or not I was going to continue to assert my innocence and therefore risk almost automatically being denied parole based upon my lack of expressing remorse as well as taking responsibility for the crime. So either I could stand on my innocence and therefore run a substantial risk of having an already unjust prison stay further extended, or instead I could falsely admit guilt, which then would cause me to run the risk that if in event I was able to get my conviction reversed, the prosecution could then use my statements in order to reconvict me as well as fight against compensation efforts later on. I repeatedly raised the issue of my innocence in front of the parole board. I already had a DNA test known at the time of trial in my favor, yet the board was unwilling to merely consider the possibility that I was innocent. Considering that the board acknowledged that I had an excellent educational record, that I had stayed out of trouble, that I had several letters of support, as well as a letter recommending that I be paroled by a prison chaplain, I nonetheless was denied parole. Although not explicitly referencing my assertion of innocence in its decision, as the Board often does in other similar situations, considering the factors that I just mentioned to you, it's hard for me not to infer that the assertion of my innocence wasn't held against me. To have a one-size-fits-all approach, which doesn't take into account the issue of wrongful convictions, is inflexible and further compounds what's already been an injustice. Turning to the issue of the parole board repeatedly use of the phrase to release you at this time would deprecate the seriousness of the crime. I'm not going to repeat the things that I just did in terms of my general parole candidacy, but I do wish to share with you, just to have the information that the board had at the time of its consideration. I had obtained a GED, I had completed an associate's degree, I had completed a further year of study towards a bachelor's, and only was forced to stop because funding was cut. I had worked a year and a half as a teacher's aide, helping other inmates acquire their GED, as well as learn to read and basic math. I had completed many vocational programs, amassed many certificates, and I had also completed the aggression replacement training program. Based on all those factors, I thought that I was a strong candidate for release. Nonetheless, the parole board used that phrase and denied me parole. As I see it, there are numerous impacts upon the repeated use of this phrase on several different levels. Firstly, it affects the morale of the prisoners. Why should they bother to participate in the educational, vocational, and therapeutic programs if the nature of the crime is going to be the determining factor? That was known before the first day in prison was ever spent. It's a waste of the state's money to provide educational, therapeutic, and other vocational programs if the nature of the crime is going to be what controls. There's a fiscal aspect to this. It costs approximately $40,000 a year to house inmates in a prison setting. To incur that cost in a day and age now where, as a society, we have to tighten our belt, to keep incurring that $40,000 a year while, as a result of holding people who can demonstrate that they've turned their lives around, is a continuation of wasting money. As I see it, that criterion should be removed as an option, and instead the assessment be made only as a result of consideration whether or not, if somebody is released, whether they would continue to remain at liberty without breaking the law. So I'm suggesting that the usage of that phrase be banned legislatively. Backing up a brief moment, I forgot to include the remedy in reference to the innocent prisoner's dilemma. I would ask the Assembly and the state legislature as a whole that in situations where parole applicants have maintained their innocence from the beginning, that it be against the law for the parole board to cite lack of remorse and lack of taking responsibility, and instead they should just assess the rest of the application and determine whether a person is, to quote other people who have given testimony here, a safe bet to release them. In terms of, on the issue of having closed circuit hearings, my hearing was held in a closed circuit. It felt very mechanical and cold. I felt like I was less than human, that I wasn't even deserving of an in-person interview. I was unable to observe body language and facial gestures on the part of the parole commissioners. I therefore had no idea if the points that I was making were being understood and I could move on, or if instead I had to spend a moment or two elaborating on those points. I couldn't see the other parole commissioners. I was repeatedly struck by the feeling like I was in some sort of bad science fiction movie. Another result of having hearings on closed circuit was that I remember having, and this came up in conversation with many other people I was incarcerated with, that if the state was willing to use a process which didn't have basic respect, that wasn't the best method of going about it, then if their process was in shambles, then what were the chances that decisions were really going to be objective? Instead, the result was the conclusion of the parole hearings was all too apparent: parole denied. And that is, in fact, what too often happened. I think that it sends the wrong message to the prison population to continue to use this method, and I therefore urge you to pass legislation abolishing it. Another aspect, the last aspect of that was that I felt that I was unable to build any sort of a rapport or have a feel for the commissioners, and I don't think that they were able to get a feel for me either. I'm sure that that's the case in other situations. Turning to a couple of appeal issues, the way that the process, I was turned down for parole, and as a result of that, I filed an administrative appeal. I was turned down there, and I filed an Article 78 in court. Being proactive as I was throughout my wrongful incarceration, I learned about the process and attempted to help myself. And so I learned, in the course of learning, I gained some insight into a couple deficiencies in the parole appeal process. Firstly, the issue of courts dismissing Article 78 challenges on the grounds of it being moot. If a denied parole applicant files an administrative appeal, is turned down, and then files an Article 78, if they appear in front of the parole board again, then the petition is deemed moot and therefore dismissed. If the only remedy that the court can grant is giving a de novo hearing, and the petitioner has already achieved that remedy without having to prevail on the merits of their arguments, then why continue? I guess that it's a cost-saving measure to get rid of unnecessary litigation on the docket. The problem, however, is that it's not unnecessary litigation on the docket. Often, many prisoners who have been denied parole and the administrative appeal and file the Article 78, when they go back to the parole board as a result of their petition being ruled on as moot because they appear in front of the parole, when people have appeared in front of the parole board again,